Any mention? May I please, Your Lordship? Your Lordship, I beg to mention item number 7.
You're appealing for?
For the petitioner, Your Lordship.
Petitioner, come. Go. Who is appealing for the respondents here?
Your Lordship, the connecting counsel, he's not feeling well. Mr. P.O.B. he is unwell.
It's all right, but then who is for the state? Who is up?
Item 7. 7 who is it? Item 7. Whose name is that?
Lordship, I think Mr. Karwanlang is in this matter. Yes.
When you inform them, they're asking for time.
I'll inform Your Lordship.
Lordship, let it come after 1 week, Lordship.
After 1 week, Your Lordship.
Much obliged, Lordship.
Newly obliged.
This is a matter after 1 week. Yes.
I beg to mention item number 12, my lord.
Yes.
I've informed the other parties, my lord.
No objection, Your Lordship.
I'm praying for 2 weeks, my lord.
My lord, I'm for the petitioner. They have filed an application for being implemented.
For impleadment, my lord.
So now you're asking for time.
My lord, I have some difficulty today, my lord, some personal difficulty. I'm just praying for.
You want to be implemented as?
Well, I want to, as the petitioner, my lord, here, because, my lord, I was the one who initiated the entire process.
They are implement in a revision application. It's not an appeal.
My lord, they can be, my lord. I'll satisfy this question.
My lord, what has happened in this case? There was a client acquisition proceedings between the present petitioner, his client, who was the then Sardar of the village. It was a conglomerate of 14 villages. At that point of time, he was a Sardar. So he had filed the claim petition before the LA court. And subsequently, the respondent number 2, he was elected as the Sardar. And without being impleaded before the LA court, within 11 days of his taking over as Sardar, he entered into a compromise with the other parties to withdraw the amount of 15 crores. But on coming to learn about this fact, now the petitioners, we, who are the residents of Ratchabong, we immediately filed an application for being impleaded in the LA case, saying that the present Sardar has no authority. He is only a representative of the people. So we filed an application before the LA court, which rejected our application. He said, no, you're not a necessary party. Against that, we have come along. And section 63 of the Act.
The earlier settlement by the Sardar,
Yes.
was it on the basis of authorization given by the...
No, my lord.
Or on the basis of any resolution of
Nothing,
Darbar?
No, not even the notice, my lord. Order 1 Rule 8, representative suit, CPC, even though CPC is not applicable, but the principles will be applied. And Order 23 Rule 3B, no compromise in a representative suit can be done without issuing notices to them. That is the crux of it.
We are at the mentioned in English.
No, I just wanted to...
Senior has already briefed the matter.
I had raised the issue also, why you have come under of 227. 63, section 63 of the new act is very clear. No,
We'll definitely ask. You see, you have to, there will be many queries in this kind
There
of
will be, my lord. I also need some more time to bring some authorities
come
before
prepared,
this court. I will.
There will be many questions.
Yes.
And just say, today we'll just adjourn. You have any objection?
No objection, Your
I'm for
Lordship.
3 months, the collector.
The request.
2 weeks.
2 weeks.
Why, Mr. Case is welcome. This is matter after 2 weeks. You will be appearing on behalf of the
Applicant.
Well, I'm the applicant.
Miss case.
Miss Case.
Miss case, my lord. Miss case 13. In miscase 13, I am the
That
applicant.
this order will be, any order was passed in miscase 13 before.
Yes. No,
Earlier,
for hearing.
for hearing, it was fixed for hearing, my lord. I mean, the matter was initially heard and
Anyway,
then the
this order
notice
will
was
be
issued.
in the miscase on the way of so and so.
They filed the
main
reply
case
also.
You just say list along with miscase number so and so after 2 weeks. Okay, or you can say just the thing just straightforward with the parties list after 2 weeks. Yes.
Obliged. I would also beg to mention item number 5, my lord, the hearing list. Mr. Sen is appearing for the matter for the government, my lord. I've informed him.
This is a matter where US probably seeing some compromise.
There was, but my lord, it did not work out, my lord. We'll argue the matter.
The matters are pending for quite some time.
Quite some time, I agree. We'll argue on the next day.
Yes.
My lord, no objection.
No objection. At the request made on behalf of the petitioner. This is matter after 2 weeks. 2 weeks.
2 weeks, my lord. Much obliged.
Yes.
May it please your lordship, I beg to make a mention of item number 4, lordship.
Yes.
Lordship, I'm praying this matter may be listed after 3 weeks, lordship.
Yes. No objection. Just say the request made by the petitioner and not object to provide the learned counsel of the respondents. List this matter after
3 weeks, lordship.
3 weeks. Yes.
Lordship, similar prayer of item number 6, lordship.
Item number 6, you are appearing?
The petitioner, lordship.
My lord, she is for the petitioner. No, my lord, she is for the NPSC. The petitioner is Mr. Nongri.
No objection,
Yes.
Your Lordship.
No objection. This also has the request made on behalf of the respondent number so and so. Okay. What will be more or less same? 3 weeks. 2 weeks.
3.
3 weeks. All right. 3 weeks. Okay.
I do oblige.
Lordship, also similar prayer of item number 7, lordship. For the respondent.
Item number 7 has already been mentioned.
10, lordship.
Yes.
No objection, your lordship.
You are happy. This item 10 at the request made on. You are appearing for the respondent number at 10? Not for all the
1, 2,
respondents.
3, lordship. 1, 2, 3,
There are 4 respondents here.
lordship.
And who is representing the other respondent?
My friend is in it.
Okay. Okay, the request made on the respondent number 1, 2, 3. This matter after? After? When? After?
3 weeks, lordship.
Weeks.
Highly obliged.
May I please, Lordship, I beg to mention item number 8 and 9 of the hearing list, sir. Connected matters.
Yes.
The matter may come up after 2 weeks, Lordship.
8 and 9. You were there, Mr. Upadhyay. Yes. Those matters.
Yes, 8 and 9.
No objection.
No objection, yes.
8, 9 as the request made on behalf of the petitioner. This is matter after 2 weeks. Yes.
Hello, oblige.
Supplementary cause list, item number 1.
Yes. Oh. Yes, Mr. Devnath. Is there any army rules? Is there any rules? There is a rule, army rule, 1954.
Yes, sir.
Any provision therein which guides that proceedings before the court and you see what is to
So,
be.
Your Lordship, as per my knowledge goes, Your Lordship, I have studied little bit, but I didn't get in such like the first school is asking. But here, Your Lordship, the process, even last week only Your Lordship
This court
said.
is asking you a question, you see, whether there exists any provision in the army rules of 1954 with regard to the holding of court martial, or
Yes,
is it there?
Yes, sir. This officer is there. I'll take a distance from her, and she knows everything. Your Lordship.
Come on.
Lordship, I would like to make few submissions before your Lordship.
No, before you just answer the query of the court, whether there exists any provision in the rules.
Lordship, as per Army Act section 125, sir, when there is a dual jurisdiction,
We know that. That was pointed out by illustrious sages.
Your Lordship,
We are asking whether there exists any provision in the rules,
rules,
the
Lordship,
manner which is to be followed in such a case,
Lordship,
where the army authority claims trial
Lordship.
the matter. At the same time, state also says
Lordship,
they have the jurisdiction.
Lordship,
Now, is there any provision
Lordship,
in the rules
Lordship,
which takes care of that situation?
Lordship, Lordship, we are totally submitting before you that we are not denying that the civil authorities do
We are
not.
asking a question whether there exists provision in the rules or not. That is what you reply. Why you are going somewhere else?
Your
If
Lordship,
there is any provision, you say yes. If there is no provision, you say there is no. Or if you say you do not know, then you take time and see and come back.
Lordship,
Your Lordship, here
Lordship,
regarding the
See, Mr. Devnath,
yes,
since you were there on the other side, probably in the BSF Act and rules, there are some provision. Dr. Mojika can probably guide you in this kind of things.
so this
See,
this
so whether there exists similar provision in the army rules or not.
similar provision, Your Lordship. Similar provision. This is the rules regarding the adjustment of jurisdiction of civil military court over military personnel accused of
What
civil.
are those rules?
This is one, this in rules 418, it says statutory rules of the central government military home affairs.
Is there any provision which speaks about doing trial from the criminal court?
So you listen just
And was it done by your authority?
here you see just if I can submit. Here we are having one problem here. What's the problem that I'm saying? You see, generally this when all the rules is coming into play,
We can understand the problem. You see, Mr. Devnath. Only thing is that the court wants to be sure whether you are following proper procedure or not.
we are
Because so far this court understands the question of quashing doesn't arise at the stage of investigation. Because there is no reason to scuttle the investigation just because you think that you should institute court martial.
so you see in this respect matters. I just say you see.
It is not that the matter has been charge sheeted and it is pending for trial. Try to understand one thing. It is at the investigation. You just please make in-depth study of the thing and then you just come back to us.
Lordship, may I please make a humble submission?
Yes, yes.
Lordship,
Mr. Lal.
the thing is, court martial is at a very subsequent stage. Initially, we are going to carry out a court of inquiry, Lordship.
Exactly, that is what. So at this stage, that is what the question of the court. Where is the provision which says that the investigation initiated by the state has to be scuttled?
No, Lordship, indeed, we are not asking you to do that. It's just that
Your
we seek
prayer is for
permission.
quashing. Your prayer is for quashing. Have you seen your petition?
Lordship,
So that is where. Then it's all right. You see, if that remains the correct position, there is then no problem. We'll dismiss your petition. This, see, probably you have not initiated the correct. See,
I understand.
this court
Lordship,
understands.
Lordship, the reasons for quashing is different, Your Lordship. Also because the people who have been mentioned, most of them are not present also on that day, Lordship. The reasons
Those are
being
merits.
brought
We
out.
cannot go into all those things at this stage. You see, this is an investigation stage. We cannot go into it. Whether you deny the allegation or accept the allegation, this court is not concerned. You want to see those provisions come back to us, or you want us to?
We'll take, your Lordship will take time.
Lordship, the point of locus has not been satisfied by the petitioner here in Lordship.
Exactly. See, the question of locus comes once we can understand that once we get a thing whether they have the right to pray for quashing.
There's
Isn't
no
it?
provision under the law, Lordship.
They have the power to initiate their own inquiry. We are not at all concerned.
Nothing is stopping them,
Here,
Lordship.
this court is basically concerned about their prayer, wherein a specific prayer is made to quash the process.
But my lord,
And you do one thing.
With all
You please also see to it. There perhaps maybe some decisions in this regard, especially seeking quashing at the stage of investigation.
my lord, if I may just submit, Lordship, can their prayer even be considered when locus has not been satisfied, Lordship?
See, the question of locus is dependent on the thing whether they can make this prayer.
But the question of locus will
Whether-
render it
see,
maintainable or
if-
non-maintainable, Lordship.
If they can show us some law which says that yes, moment they initiate the inquiry, the investigation has to be passed. If they show it, then definitely we can say they have locus. But then otherwise they do not have. because this present investigation initiated by the state has nothing to do with Union of India. It is only those individual persons in their individual capacity. So that is where the question of locus comes.
Lordship.
Okay, just please see that part.
Lordship.
You got the thing or not? Or maybe you did not get that.
Totally understood, Lordship, but I still have my reservations with regard to their
No, that
petition.
is, the court also has the reservation, and that is why the court basically dismissed this matter.
Lordship.
Now thereafter, suddenly it came to the notice of the court about the existence of those rules.
Lordship.
Now probably the learned CGC on the other day did not address us on that.
Lordship.
But that is why this matter has come back again. We'll list this matter. How many respondents are there?
Responded state is 1 and 2, and then
We'll do one thing. We'll issue notice. We'll keep this question of maintainability open.
Lordship.
Mr. Devnath. Learned CGC. Appearing for the petitioner. Issue notice. Returnable in 3 weeks. MS NG Shilla. Learned senior PP. Senior PP.
Public prosecutor, Lordship.
Senior PP or PP only?
Public prosecutor, Chief Public Prosecutor, Lordship.
So, learned. You have to write. Then you have to be CPP.
Lordship, that is what I got in hand, Lordships.
Okay. FTS on behalf of the respondent 1 and 2. The petitioner shall take steps for service of notice upon the respondent number 3 within 2 days. List after 3 weeks. The question of maintainability. Just give a paragraph. Do not say list after 3 weeks. Before that, petitioner to take steps so and so. Then you give a paragraph. You say the learned senior PP or learned PP has challenged the maintainability of this petition. Question the locus standi of the petitioner and maintainability of this petition. Stop. The question as to the maintainability is kept open and will be taken up on the next date fixed.
Lordship. Much obliged, Lordship.
List after 3 weeks.
Daily cause list, item number 1.
Please, Mr. Devnath, please see, verify that part of the rules. Please clear. This court is not very clear with about those things. Please see, and then probably you will find certain procedures.
Now, this procedure actually, illustrative in this case, whatever I studied right now, this matter has come up generally. Permission is coming up, central government permission after the charge is filed. Whatsoever I understood, but in this case, already central government given the permission.
Just see.
So this is the matter.
Please see,
So,
verify.
before this even charges come, but central government given the permission. So this is the matter here.
Okay, please enlighten that book.
Much obliged, Lordship.
Lordship, in this matter, I am maintaining appearance on behalf of the sole respondent. Notice was issued to the respondent, but the petition was not engrossed. I may be served with a copy of the petition, madam.
Yes, you serve them a copy of. You have taken steps without supplying a copy of the petition.
Your Lordship, I have no idea about that. I'll seek instructions, Your Lordship.
Wait, who are you? You are not petitioner.
I am for the petitioner, Your Lordship.
Then,
But then I have to seek
when you
instructions.
take steps, you do not furnish a copy of the petition. What Learned Counsel for the respondent contents is that he has not received a copy of the petition. You have to supply him a copy of the petition.
Okay, Your Lordship.
Will supply Your Lordship.
Yes, please. That is what. Yes, Mr. Ahmed. M.U. Ahmed. Learned Counsel has appeared on behalf of the respondent today and submitted that a copy of the instant revision petition has not been supplied to the respondent. The Learned Counsel for the petition undertakes to supply a copy of the same during the course of the day.
Yes, Your Lordship, in the course of the day.
Then when shall I list this matter?
After 2 weeks, madam.
List. As per for the parties, list this matter after 2 weeks.
Much obliged.
Much obliged, Your Lordship.
Item number 2.
File the reply. The reply was supposed to be filed. Reply has been filed by the private respondent.
Yes.
So the matter can proceed for hearing.
You have received a copy of
I've received a copy.
Yes. Who was supposed to file the objection?
Respondent number 3, Your Lordship.
Number 3. Yes. Okay. It is submitted by the learned counsel. Oh, the there is only how many respondents are there?
Two are state respondents. The third is the private respondent.
And what is your prayer in this matter?
But to quash the entire proceedings, no case is made out.
Then is submitted. There is an objection on behalf of the respondent number 3. Has been filed. Just say Mr. M. Lindell, learned counsel, submits that an objection on behalf of the respondent number 3 has already been filed. Mr. Gautam, learned counsel, the petitioner acknowledges receipt of a copy of the objection. Copy of the said objection. Stop. Your paragraph, the party submit, the matter is ready for hearing. Accordingly, this matter for hearing after
2 weeks.
2 weeks.
I'm for the respondents, stage 1 and 2.
Lots of time place it time after 3 weeks.
okay, 3 weeks. Make it 3 weeks. After 3 weeks.
Obliged.
Item number 3.
But the respondent number 2 was served on, and as per last order, my lord, the direction to wait for.
2 has not entered appearance.
Last time also, today also, I don't think.
All right. Then we will proceed. But then this is a criminal petition. No need to pass any order for ex parte proceeding. That will remain. So what shall we do? Shall we list it for hearing or shall we?
My lord, I'm led by Mr. Misra, my lord. It's requested for 3rd or 4th of April, my lord. Sometime.
You need you yourself is the leader. Then why? Huh?
Sir, doubling.
Then when
3rd or 4th of April. Either 3rd or 4th of April. 3 weeks.
Date becomes very difficult.
First week. Oh, you need a particular date. April, well, it's Thursday or Friday. Man.
Thursday or Friday.
3rd or 4th, any of those dates.
That will be all right. You will be all right. The learned counsel. Despite service of notice, the none entered appearance on behalf of the respondent number 2. Stop. The learned counsel will appeal for the petitioner and the senior counsel appearing for the petitioner and the learned PP for the state appearing for the state. Submit that the matter is ready for hearing. Stop. Then you say as prayed for list this matter on 3rd April for hearing.
At the interim order continue.
Stop. The interim order passed earlier shall continue until further order.
Okay.
He's not unhappy, Mr. Khan is not unhappy.
I'm deeply.
Hearing item number 11.
Yes.
Mr. Lordship, as per the order dated 27
Item number 13.
Lordship,
Yes.
this is an application under section 482 for quashing the FIR. Your Lordship, precisely my case is this, that on the face of the FIR, no case of the commission of any offence is made out. Secondly, my submission is also this, that the dispute is purely of a civil nature and an attempt has been made to give it a color of criminal case. I will straightway take to your Lordship the FIR.
Yes. Page 16, is it annexure 1?
Yes, Lordship.
This is a case registered under what section of law?
Under 420, 468.
Okay. Cheating, forgery.
Yes.
Yes.
Page 16, your Lordship. This is the FIR dated 14th March 2023. The first paragraph says that I am the authorized person holding a valid authorization letter issued by Shrimati Kusum Gupta, wife of late Shiv Jatan Gupta of Japasilja Post Office and PS Lakhimpur, Assam, to represent Shrimati Kusum Gupta in respect of her land owned by her at Garo Hill, Meghalaya, by way of inheritance from her deceased husband, late Shiv Jatan Gupta, situated at Fancy Valley, Tura, covered by PP number so and so, measuring 1 katha 3 lassa, under Moja number 10-1, West Garo Hill, Meghalaya. Photocopy of the letter of authority duly notarized and the copy of the land patta in the name of Shiv Jatan Gupta are enclosed as annexure 1 and 2 for your kind perusal. You see, just a bare reading of paragraph 1 doesn't say anything about the commission of the offence. It is just a statement made by the informant that one authority letter has been given by Kusum Gupta. Now the question is that whether Kusum Gupta is the recorded owner or landholder of the land in dispute. Your Lordship, this is the admitted position from paragraph 2 that to my knowledge, after the demise of late Shiv Jatan Gupta, the said land has not been mutated in the name of Shrimati Kusum Gupta. This is the admitted position, Your Lordship, that she is not a recorded land owner under the Meghalaya Land Revenue
regulations. And once she herself is not the landowner,
Yes, please.
once she is admittedly not the landowner
She's
or
not the recorded owner.
Recorded
But then it is
landowner,
undeniable. You are not disputing that she is the wife of late Shivjatan Sharma, isn't it? Shivjatan Gupta. You are not disputing that.
I'm not disputing that. I'm not disputing
Yes.
that. But the point remains here that
In 482, do you expect this court
no,
to go into
Your
all
Lordship,
those questions?
certainly not. That's why I have placed paragraph 1, that paragraph 1 doesn't make out any offense.
Yes.
Then come to paragraph 2.
Yes.
That to my knowledge, after the demise of late Shiv Jatan Gupta, the said land has not been mitigated in the name of Srimati Kusam Gupta, and that by virtue of such authorization, I have been authorized to induct tenants in the property of Srimati Kusam Gupta since the date of authorization, that is July 2019. Paragraph 2 also doesn't make any offense. Then come to your Lordship, paragraph 3. That to my utter surprise and dismay, Srimati Annu Jain Bora, wife of Shri Sumit Jain Bora, being my younger brother's wife, have issued eviction notices to the tenant living under occupancy under the said property of Srimati Kusam Gupta, wife of late Shiv Jatan Gupta, claiming herself to be the landlord of the property in question. The said letter dated so and so in photocopy is marked as Annexure 3 for your kind perusal. Further, Srimati Annu Jain claims the property to be Bora House on perusal of the said letter of eviction. The allegation which comes from paragraph 3 is only this, that I have issued letter of eviction to the tenant.
To their tenant.
To the tenant.
To their tenant, that is what they say.
And
Anyway.
to their tenant. But what I am telling, that it is me who have.
It's all right. These are all civil questions, who owns and all. So right now we are not concerned with these things. Come to the part where this 468 and 4 these things are concerned.
Your Lordship, I am just to take, there are hardly 5 errors. From paragraph 3 also, no offense is made out.
Yes. No, you can go, but then you see, so far as this court understands the reading of paragraph 1, 2, and 3, if at all there exists any dispute, that is totally civil.
That is totally civil.
Yes.
If at all there is a dispute.
Yes.
Then come to paragraph 4, Your Lordship.
Yes.
That it is pertinent to mention that in previous occasions, the very approach of my younger brother and his wife, both portraying themselves in the estimation of other people to be the landowner of the said property, portrayed as Bora House, prompted me to approach the office of the Garo Hill Autonomous District Council, Tura, to ascertain the status of the property on the strength of my stated authorization letter, on the basis that Srimati Kusam Gupta resides in Lakhimpur, Assam, upon which I learned that the property in question has been mutuated in the name of my younger brother, Shri Sumit Kumar Jain Bura, in the revenue records of the GHA.
My younger brother means the
Madam,
attorney holder's younger brother.
Younger brother. Younger brother. The informant is the brother of the accused petitioner number 2.
What is your name? Who are you?
I am Anu Jain Bora, Srimati Anu Jain Bora,
You are
and,
Anu Jain Bora.
and Sumit Kumar
Okay.
Jain Bora. And the complainant is Amit Kumar Jain Bora.
Okay.
Now here your lordship will find from the paragraph 4 that upon which I learned that the property in question has been mutuated in the name of my younger brother. It's also the admitted position that I am the recorded owner of the property. In this stated context, if such illegal mutation has happened, then Shri Sumit Kumar Jain Bora, being a non-tribal, has no right to purchase any property or get the land mutuated in his favor from late Shiv Jatan Gupta, the original owner of the land, in terms of the provisions of the Land Transfer Act of Meghalaya. Further, any act, deed or things done towards such illegal transfer would only be possible through an act of criminal conspiracy, cheating, fraud, impositions and provisions of the Indian Penal Code. Your Lordship, the reading of the second part of paragraph 4 will reveal that it is a hypothetical allegation that if this thing has happened, then this must have been happened in this manner. And it is not that he is alleging that I have committed. He says that in case this thing has happened.
He questions the validity of the mutation. He questions the validity of the mutation.
Validity of the mutation.
So what FIR has to do with the validity of mutation?
That's the point.
Yes, and then what else here is there?
Just 2 para more, your Lordship.
His contention is that your name has been entered in the revenue records, and you being non-rival, the land could not have been legally transferred to you.
Yes.
Now that is question concerning the validity of the transaction.
Validity of the transaction
doesn't say that these entries have been made by you, it was overwritten.
There is no such allegation. There is no such allegation.
Then what remains in this matter then?
Nothing remains, your Lordship. Just I will complete 2 paras.
Please. Go ahead.
That the very letter of eviction clearly spells the conduct of the duo couple who are not authorized agent to take any step to issue eviction notice. This is also your Lordship.
These are all.
Paragraph 6, that it further transpire that the revenue record of Gaurav Hills Autonomous District Council should be inspected accordingly as because Shri Sumit Kumar Jain Bora hold influence in the town, and that his character antecedent could well be seen from the enclosed FIR dated 22/3/21.
What is that? Another FIR is there.
It's not there.
And closer 4.
Though he stated that it is enclosed, but I didn't find there is only
Any enclosure is here? Yes.
No, Your Lordship.
There is nothing.
We haven't received any.
no,
Because
because it was not filed as
I will take it as that there is no enclosure.
there is
although
no.
there is, it is written in the first paragraph, Your Lordship,
Yes.
of the
But
FIR.
that becomes
Enclosure
even
1 and 2 for your kind
But-
perusal.
that-
I think the
You are
private
the state,
respondent.
You are the state. The FIR is with you, isn't it?
Private
So whether
respondent
FIR
might be
contains
able
any
to say,
enclosure or not, that is for you to say.
Yes, Your Lordship.
This contention of senior counsel is that it is not there.
It is
It's not there.
So you are
We
not
have
rewarding
also
it.
not received.
You are not rewarding it. So that is what. Okay. Yes.
Your Lordship, basically the dispute, as Your Lordship has rightly pointed out, is relating to the mutations. Your Lordship, there are 3 judgments which I will place.
What judgments is needed? First, let them reply to your contention. You see why? Judgments will see what you say, that even the allegations made in the FIR accepted.
Yes.
No case will be made out.
Yes.
Now that apparently it seems so. Okay. So let us
Secondly,
see
Your
what the
Lordship,
other side says.
no,
I don't think you need to make any more submission apart from what you have made already.
no, only to Your Lordship substantially that here the jurisdiction not with the police, but under the regulations, it is conferred upon a particular authority.
Yes. Who is that authority?
That's what Your Lordship, I just wanted to point out. Your Lordship will see the judgment of the Supreme Court, which came from Meghalaya only.
Yes.
That is 2011, 11 SCC 628. Your Lordship, I'll just read paragraph 3.
Just a minute. We have not received the. Yes.
I'll just read from paragraph 2. The suit was dismissed by learned Munshi Barpeta on the ground that the plaintiff had not produced any document to prove his title, and the entries made in the revenue records were not sufficient for declaring him as owner of the suit property. That was the view of the Munshi trial court. Then first appellate court, during the pendency of the appeal, the plaintiff and the defendant died and their legal representatives were brought on record. After analyzing the pleading and the document produced by the party, the lower appellate court held that the plaintiff respondents had been able to prove their title. The lower appellate court noted that as per the certified copy of the Jamabandi Exhibit 1, Patta number so and so, containing dag number so and so, stood in the joint name of Balindra Narayan Adhikari and Muhammad Datta, that as per the endorsement in the remark column of Exhibit GHA, the name of Balindra Narayan Adhikari was mitigated in respect of the suit land measuring so and so, covered by the new dag number so and so, along with Chandra Kumar Chaudhary and Dev Kumar Chaudhary, by right of purchase in terms of ASO order that is so and so. The lower appellate court then proceeded to observe, this is important, Your Lordship, it is not the case of the defendant that these endorsement in the record of right erroneous. It is true that entry in the record of right does not create or extinguish title, and such entries are rebuttable. There is not an iota of evidence to show that Exhibit 1 KHAGA and GHA are erroneous. It must not be forgotten that the original plaintiff and the original defendant had since expired during the pendency of the suit, and the suit has been contested by their legal heir, so no fault can be found with the plaintiff even if they fail to prove or produce the original sale deed in respect of the suit land. In the absence of any evidence that the entries in the record of right were erroneous, I am inclined to accept the entries in the record of right as correct.
That is with regard to court proceeding.
Yes, so here entries are made in the record of it is
That
undisputed.
is all right. You see, we have no dispute with what you are saying. But so far as this decision is concerned, we don't think like we have see anything to do in a court application here. Now you say that
Jurisdiction.
you say that if there is any such illegal transfer that is in violation of Land Transfer Act, then in such a case, police is not the authority. There is some other authority. Who is the other authority?
That I am just telling you.
Just come to take us to that point.
Right, sir.
Though the decision which you are citing, we don't find that it is basically would be relevant here.
No, Your Lordship, here I took time to find out the title deed on the basis of which the entries in the Jamabandi were made.
You are not required to show all those things here.
Yes, that is civil matter.
Basically, this court cannot go and look into the documents which you have appointed.
Yes, Lordship.
That is only thing is that now what you have stated,
sir,
that this allegations made in the FIR doesn't make out a criminal case. Now let us see what reply they give.
Right, sir.
If you have any other point to make, you make it.
Right, sir. Only that judgment I want to place.
No, what for? See, this judgment basically also this court doesn't find it very relevant. That is where the finding of the court in a civil proceeding.
In a civil proceeding.
That is all right, but then this is nothing. It has what bearing it will have here?
It, sir. Now, Your Lordship will take the one Guwahati High Court judgment.
Why you are burdening the court with the things when court is still now with you? We do not know what is the decision about.
That patta once issued cannot be cancelled.
That is we are not at all deciding all those questions.
Right.
Kindly appreciate that. We
right.
cannot also. If you want also, we cannot.
Right.
What we are concerned about is that
whether any offence is there.
If any illegal entry is made in records of mutation, how can that become a criminal offence? This is what let them say.
And here you know whether it is made or not, that is also not stated.
That is all right, but even let us assume that it has been made. But how it becomes a criminal case here?
Right, sir.
Yes, please. Address us on this issue, madam. We do not want to go for a lengthy hearing.
Lengthy hearing, yes,
just give us this, that the even allegations at paragraph 4. If we accept it also, how it becomes a criminal offence?
The Lordship had asked me whether the enclosures in the FIR, that is letter of authority, and the patta was there. We have just found out from the records, handed over.
FIR. Previous FIR.
This is that FIR dated 14/3/2023, Your Lordship, which my learned friend had just read out. Now, in the first paragraph, there are 2 enclosures, enclosure 1 and 2, for your kind perusal, and Your Lordship had asked me if we have got a copy of that. Now, I just found out from the records, Your Lordship, that the letter of authority, which is enclosure 1, is there, by which Mrs. Kusum Gupta, the wife of Shiv Jatan Gupta, had authorized Amit Kumar Bora to look into the matter as to how this property, which belonged to her husband and which ought to have been in her name, has gone into the name of somebody else. That is the petitioner number 2, Your Lordship. Then, Your Lordship, they have also enclosed a patta, which is
what bearing it has here?
No, Your Lordship had asked me, so I just want to clarify this. The patta also stands in the name of Shiv Kumar Gupta, Your Lordship. Shiv Jatan Gupta, my husband. And the original original patta is here, Your Lordship.
That is all right.
Now, Your Lordship, it is to be seen now as per paragraph 4 of the FIR, Your Lordship. It shows that these people have been trying to portray themselves as the owner of that property and also named the house as Bora House. That is my property. But they have illegally, their act is criminal, Your Lordship, because they have illegally trying to show themselves as the owner of the property. Whereas they are only the tenants. They are not my they are not the owners of this property. And then, Your Lordship, they have also said that the act.
Who are the petitioner here are your tenant, your state. They cannot be your tenant, isn't it?
No, they are not my tenants.
Yes.
No, Your Lordship, may kindly see. They are also staying in a rented house, Your Lordship. It is not a disputed fact which has come in course of investigation. And Your Lordship, the private respondent.
What is the stage of your investigation?
The stage of investigation, in fact, it is almost complete, Your Lordship. The case record, in fact, the private respondent will be able to enlighten Your Honor as to the position of the who is the owner of the property, how it all.
We will not go and
yes,
decide
Your
that, madam.
Lordship.
Kindly appreciate that fact. In the 482, we have a limited jurisdiction.
Yes, Your Lordship will just have to see whether there is a prima facie
we
case.
just confine ourselves to the allegations. Even we will not see what Mr. Jindal produced before the court. If he comes with the document of his ownership also, we are not going to look at it.
But the property as of now stands in my name, Your Lordship.
We do not know, but then see,
that is why, Your Lordship.
See, the thing is that
in para 4, Your Lordship, they have stated clearly.
Kindly think the grievance which has been raised in this FIR is with regard to the entry made in the land records.
So in that case,
that is what we are, and then and the only allegation is that the name of Mr. Sumit Kumar Jain Bara has been entered in the records of mutation, totally in violation of the land transfer act.
Totally in violation, and that there is a conspiracy. That is what they have said. There is a criminal conspiracy, and they have done it by causing a fraud.
Criminal conspiracy between whom?
The GHADC, Your Lordship. Some of the staff of GHADC has also been been arrested, Your Lordship, and their case is also pending before Your Lordship.
Whether any suit has been civil suit has been filed.
Filed by
claiming ownership.
I understand that there is a civil suit, Your Lordship, pending. But in the meantime, Your Lordship, in this case, the GHADC also should have been made a necessary party. Because there is a conspiracy with some of the staff and officials of the GHADC, Your Lordship.
That is, you see, this illegal mutation, that is what the contention is. Now, whether this illegal mutation has been struck off from the records or not, and
Your
what
Lordship,
proceeding has been lodged.
If there has been an illegal mutation, that means there has been a criminal act committed. A criminal act has been committed.
That way, madam, each and every this is criminal act.
No, if there has been an illegal mutation.
Even a landlord-tenant find also will be a criminal act. If a landlord tells somebody to vacate his premises, if the tenant doesn't vacate, then it becomes a criminal act. If you go by your
by my submission, but no, Your Lordship. In this case, Your Lordship, this is a.
See, madam, illegality and the criminal act are two different.
But if there has been a fraud committed on somebody, Your Lordship, would that not amount to criminal act?
So in the FIR, any allegation where it said that thing that fraud has been done by the petitioner.
Further, any act, deed, or thing done towards such illegal transfer would only be possible through an act of criminal conspiracy, cheating.
You cannot make a general statement in the FIR.
So
and
unless
expect a criminal case to be instituted against somebody just by saying that yes, this can be done only if a person enters into criminal conspiracy, without showing that the criminal conspiracy is done, without even narrating when it was done. When this entry was made in the
Your Lordship, it was done only recently, because till 2009 also, Your Lordship, the property stood in my name.
No, that is, you see, you are saying your name, your state, you do not hold any property here.
I don't hold any. No, it is my husband's property.
The private respondent or representing the state?
I beg your pardon, Your Lordship.
You are representing the state, or you are?
No, I am representing the state, Your Lordship.
Why you are saying that the property stands in your name?
Sorry, Your Lordship. The property stands in the name of Shiv Jatan Gupta, who is the husband of the private respondents. Your Lordship, in that case,
when this entry has been made in the mutation, record of mutation,
they show that it has been done after the Land Transfer Act has come into.
Just tell us when.
Because, Your Lordship, even as per the latest receipt, revenue receipt and all that, Your Lordship, the property does not stand in the...
Yes.
It's registered in 2021, Your Lordship. Sorry for
2021,
interruption.
Your Lordship. 2021.
This mutation has been made.
Yes.
This is the last mutation. Before that, in 1969.
How?
Last mutation is in
Because
in
on the last occasion, Your Lordship,
Last mutation is between the family member of the petitioner. There are 4 family members.
Now, when this name of Sumit Kumar Jain came, when it was entered, we are concerned with Sumit Kumar Jain. We are not concerned with any other thing.
Sumit Kumar Jain, first they say that it was in the name of their.
Diochin Jain.
It shows as on.
Anyway, we'll record your submission there.
2021, Your Lordship.
26th of October 2021, Your Lordship.
Your Lordship.
Like that. Page.
Yes, Your Lordship.
Yes, Your Lordship. Page 39, Your Lordship, of the
37,
petition.
38, and 39 of their application.
Now, how do you know it was done by way of inheritance or not?
How can it come? Because it has not even shown who did it belong to. The property was standing in the name of one Shiv Chatan Gupta, Your Lordship. So how it could have been inherited by Sumit Jain Bora, who is not even the son of, remotely related to him.
This house is known as Bora House, isn't it?
It is not known as Bora House, but they have named it as Bora House. The petitioners have named it as Bora House. They have been issuing eviction notices to the tenants. These officials of JHADC, 2 of the officials were also arrested on the basis of the same FIR.
Definitely, they stand at a different footing. We are concerned about with the
because there was a conspiracy. They have tampered with the records. Yes, Your Lordship, in this very case, on the basis of the same FIR, Your Lordship. And they are also before Your Lordship for quashing the FIR.
Any statement recorded with the police in connection with this under 161? If at all recorded, can we look into all those things?
That is my humble submission is this, Your Lordship. The statements have been recorded, but Your Lordship may not feel it necessary to delve into that.
What the law says? What the law says?
The law says that Your Lordship, that the court may not delve into the evidence and go into the details of the case. Only Your Lordship will have to be satisfied if there is a prima facie case for quashing the FIR, Your Lordship.
But that is we understand. But then
unless and until
appreciate that whether the allegation contained in the FIR constitute a criminal offence or not, to ensure it, can we go into further details? Can we look into a 161 statement?
That Your Lordship may not.
Just tell us what the law says. See, say supposing during the pendency of the case, if the matter is charge sheeted,
of this case, Your Lordship,
we can say, supposing if that situation comes, we can definitely quash the charge sheet also. But then, before doing that, can we look at the materials on the basis of which charge sheet is prepared to appreciate whether
Your Lordship will have to look to appreciate what is the
Yes, Mr. General, what the law says. What is the law? Can this court go into all those things?
No, Lordship, my respectful submission, this court cannot go.
But then there is some
but unless Your Lordship goes into it, how will Your Lordship determine?
Even if the case is charge sheeted, the FIRs can still be quashed. That is the judgment of the...
That is all right. That is the Supreme Court. You see, Supreme Court has recently said, repeatedly has said, that just because it is charge sheeted cannot be a reason for rejecting.
Yes. The question is whether court can look into those...
This question is not on this. The court is asking to appreciate the pleas raised by the parties. Can we go into the statement recorded under 161 or 164 at the stage of investigation?
No, sir.
Or no?
No.
Now, if we confine ourselves to the proposition of law laid down in the Vajanlal's case, it still holds good. It says that if FIR, acceptance of the allegation made in the FIR, doesn't constitute any case, that will be good enough for us.
Good enough.
Doesn't continue to, constitute any criminal offence, then that will be good enough.
Good enough. And
Now,
whatever,
from there, we understand that yes, we have to confine to
FIR only.
But then there may be some further law in this.
At least to my knowledge, there is none which I have come across. State can go into this aspect, and if there is any such, can file.
Because as per the investigation, Your Lordship, there is prima facie case against these petitioners, Your Lordship.
Can you look into all those things?
That is why, Your Lordship. But then I have the papers with me, and in interest of justice, Your Lordship, in the interest of justice, Your Lordship, if the FIR is quashed and investigation is not allowed, then Your Lordship, the entire purpose of the FIR is failed.
What about those proposition of law laid down in Vajanlal's case?
Then let us look into it, Your Lordship. We will look into it, Your Lordship, and bring the
Lordship.
Because even, Your Lordship, according to their own, at page 46, 45, Your Lordship, which has been attached in their criminal petition, Your Lordship will see a general power of attorney was given by Shiv Jatan Gupta to the petitioner number 2, Your Lordship, who claims to be the owner now. Why would Shiv Jatan Gupta, the actual owner of the property, give a power of attorney to Sumit Kumar Jain, who is the petitioner number 2 here and who claims to be the owner? Why would they give him the power of attorney, Your Lordship? So there is definitely something very fishy here. This is their own document which they have enclosed with their criminal petition.
We will not go into the questions which is not
Lordship,
otherwise.
Lordship, I was, just give me 1 minute. I was referring to the provisions where the jurisdiction is conferred upon the commissioner. That is Rule 26 of the Meghalaya Land Revenue Regulation.
Rule 26, Meghalaya, where is that?
Meghalaya Land Revenue Regulation.
Rule 26.
Rule 26.
Oh, where is it?
Meghalaya Land Revenue Regulation. No, it should be here. This Mahanta's book, not there.
This is a mediation by district council, isn't it?
Yes.
Your Lordship.
Now,
at this Meghalaya Land Revenue Regulation is applicable to the DA.
Meghalaya Land Revenue Regulation is applicable. Because this is an adaptation of the Assam Land and Revenue Regulation.
Yes, after adaptation, there have been other
some
notifications.
amendments.
District Council has also passed an act.
They have
by
adopted
which,
it.
Yes, by which
Garo Hills specially.
Garo Hill.
That has been adopted by the Garo Hills.
Yes.
Yes. So then there is an amendment to show that who will be the equivalent to commissioner.
Yes.
There is amendment
to the rules.
Yes. After this is by the district council after they adopted it.
Yes.
Because the post of commissioner does not exist in the hierarchy of the district council. Okay.
Okay.
So that who would commissioner mean? Whether that has been amended. Okay.
Yes.
So these amendments will be available here. So what is the provision you say?
Rule 26.
Where Assam Land Regulation?
The same actually. It is ditto. This Mahanta's book should be there in the library.
Rule 26. Rule 26.
This is 4 lines, Your Lordship can read it.
Yes, that's
Rule 26. Rule 26.
This court goes into all this. How can you... Now see something else.
It speaks about this thing, confirmation and cancellation.
Confirmation and
Cancellation
cancellation.
of the settlements. Settlements.
Settlement is same pata. That is settlement.
Settlement is something probably new. You see. It has nothing to do with mutation.
Settlement, your lordship,
Mutation
when
is not a new
mutation,
settlement. Mutation is only in the change in the records revenue of the
Revenue
records. It is not new settlement. Now you say about settlements. What you have this thing, confirmation and cancellation of settlement. Now, anyway, the thing is that probably there will be provision for cancellation of the mutation also. The parties can raise it.
Parties
now,
can.
we do not know, normally in case where the party finds the wrong mutation has taken place,
Yes.
it is for that party to file appropriate application before the revenue authority.
Revenue authority and the revenue
And
authority.
we do not know whether that has been done here or not. Now, instead a criminal case has been, FIR has been
registered.
So that is one aspect of the matter.
Yes. Your lordship, there is one judgment which my lordship may like to read it. That is Mr. Lahiri's submission. On Mr. Lahiri's submissions, that even if a fraud is committed, then also the matter has to refer to the civil court and not the criminal investigation.
Where is the finding? This is a finding.
Not finding. This is a judgment of where Mr. Lahiri appeared. That is 1951 AIR Guwahati.
But you are reading from his submission, isn't it? We are not concerned. We cannot go by that. That is his submission. You are reading the part of his submission.
No. After his submission is recorded, then the court has given its findings.
So that is what you just say. Give us then. If you have that, then show us.
Yes. That 1951 AIR Guwahati.
It says that even if there is a fraud in
Yes.
the revenue records, then parties will have to go to civil court.
Civil court.
It is not a criminal
Things.
Very surprising.
Paragraph 3. Mr. Lahiri for the respondent has frankly stated that there is no section in the Assam Land and Revenue Regulation which empowers the Deputy Commissioner to cancel periodic patta once granted to a person. There is only provision for the annulment of the periodic patta which takes place upon non-payment of land revenue. If there is no default in the payment of land revenue, the patta cannot be cancelled. In this case, it is not disputed that there was no default in the payment of land revenue. It may be true, as the learned DC appears to think, that the amicable partition which inflicts the revenue authority in getting two separate periodic patta to the appellant and the respondent respectively may have been brought about by the machinations of SK. There may or may not have been fraud. Assuming there was fraud, nevertheless, the revenue authority under the regulation had no power to cancel a periodic patta. They must refer the party aggrieved by an alleged fraud to the civil court for settlement of the respective rights of the party.
Yes.
I accept the concession made by.
But then it has nothing to do with criminal. That is so far as the rights of the parties are concerned.
Yes.
But then it doesn't say the matter stands excluded from the purview of the criminal. No, it is not that. It is not at all applicable.
May I please, Your Lordship?
You see, it is not what you want. What you are trying to say, that this basically excludes the jurisdiction of criminal authority.
Yes.
It is not. It is not. It is only for the purpose of determination of right of the parties. Yes, Mr. Pakse, Mr. Paske.
Your Lordship, just few submissions, Your Lordship. Page 4 of the petition, Your Lordship. Page 4, para 4.
Page 4, para 4 of the petition.
Yeah. The last sentence, which starts from later DOJ. Page 4, para 4, Your Lordship.
Yes. Yes.
The last paragraph, Your Lordship, para 4, last paragraph, it starts with later. Your Lordship has it. Later,
Page 4, para 4 of what? Page 4, para 4 of what you are referring?
Of the criminal
of the petition. Of the petition.
Yes, page 4, para 4. Para 4 stood with that the petitioner states.
Yes, Your Lordship,
Yes.
just the last sentence, Your Lordship.
Yes.
The last sentence of the para. Later, Diochan Jain Bora.
Last sentence of the paragraph.
Of the paragraph.
Yes.
5 lines from the bottom. It is later Diochan Jain Bora.
Oh, that is not the last line. Thereafter
The last
also there is
sentence.
another line.
Last sentence.
There also there is another line. It starts from the same.
Oh.
It starts from later. Yes, later.
Later, Your
Yes,
Lordship.
yes.
I'll start from later. Later, Diochan Jain Bora gifted his portion of 12 lesser land to his grandson, that is the petitioner number 2.
Yes.
The same has been properly mutated in favor of petitioner number 1 and 2 and later further divided. Your Lordship, then para 5.
Yes.
Last sentence, Your Lordship.
Yes.
It is also a fact. Your Lordship
Yes,
has it?
yes.
This is an admission by name which says that it is also a fact which needs to be mentioned herein that the actual plan was to sell the property in favor of the petitioner number 2 because of the legal provisions in the Meghalaya Land Transfer Act 1971, and hence late Chief Jatan Gupta had to give power of attorney to Sri Sumit Kumar Jain Bora, in which Srimati Kusam Gupta is one of the witnesses. It's a clear admission that there was a transaction here which needs to be. Yeah, Your Lordship, they mentioned about gift, but there is no gift with annexed. There should have been some gift that should have been annexed. And they themselves, they are telling that there was some sale and purchase.
Now that regards to see the start of the paragraph 5. It says with regard to the remaining portion of the land.
Yes. I purchased half.
So which way what you are trying? You are trying to say something which
Your Lordship, then I'll take you to annexure 4.
No,
page
there is no
28.
question, Mr. Paske. If you make some submission, please make it correctly. You have not seen the first part of the thing. This part is concerning the remaining portion.
The general power of attorney executed in favor of the petitioner was for the entire plot of land.
No, but so far as the paragraph 5 is concerned, the line which you have written this thing is concerned to the remaining part.
The GPA annexed by them as annexure 5, which is at page 83, Your Lordship.
Anyway, this court will not go into all those things, what has happened and what not has happened, and we'll just confine ourselves to the FIR until and unless you show some law that we can go into other things. FIR and the documents enclosed with the FIR. What is the enclosure for? What is the enclosure for? You place it before us. What is the enclosure for the FIR?
Your Lordship, may keep it for next date. I'll be placing it, Your Lordship. I'll place it before Your Lordship then.
There is a finding recorded in you filed an anticipated bail application.
Yes, Lord.
And there is a finding recorded by the court here.
Yes.
That matter is prima facie civil.
That was an observation.
No,
It was an observation.
would agree with the parties that prima facie it does not appear to be a case.
Yes, Lord. It is there.
This is giving us information when is taking note of the FIR would agree with the parties that prima facie it does appear to be a case of civil dispute.
Yes.
That is paragraph 5.
Observation, Your Lordship, it is-
And this was done the analysis on FIR. And that is what we are doing, nothing more than that here. Do the court exercise any wider jurisdiction than the bail matters in 482?
Bail matters, Your Lordship, only whether the party is entitled to bail or not,
So
Your Lordship.
482 is wider.
But 482 will definitely be wider because Your Lordship will have to see whether the FIR is required to be quashed on the basis of the
No, say
other.
supposing,
So
supposing.
Your Lordship may kindly allow us some, will because
No, see,
Your
see,
Lordship has raised some queries which I have to go into it.
see,
Your
you
Lordship.
get some more queries.
Yes.
This is a scope for the court also to get analyzed.
Both of us, Your
Yes, so the
Lordship.
question is that now Bhajanlal says that if FIR, the content allegations made in the FIR, is accepted and no criminal case is made out, then it will be a case for quashing. Now, from what we get is that we have to scrutinize the FIR. We will not go into the detail to appreciate whether allegation is correct or not, but then we have to scrutinize and treat it as correct and see whether any claim has been made out. Now, if that same FIR is scrutinized by a court at certain point of time and a finding has been recorded that it appears, prima facie it appears. That is what we also do here. And if that finding is
Only
recorded,
for the purpose of anticipatory bail, Your Lordship, hardly any scrutiny was done.
what is the difference?
At
Appreciation
the
for
initial
the
stage.
if anticipatory bail is granted on the pretext that it appears it is a civil dispute, which way we take a different view.
No, Your Lordship, that was there was no investigate. That initial state of investigation was done, Your
That is
Lordship.
where this court has
Now
already told you. Show us any law
So
that you can go into further
into
document.
further, let us.
161,
Okay,
160.
Your Lordship, I will try and satisfy Your Lordship by the next stage, Your Lordship.
See, we are coming back to the same thing. See,
Same thing, Your Lordship. Because if Your Lordship can, because under my humble opinion, Your Lordship, it would be prudent on the part of the court before quashing an FIR, Your Lordship, to go into the background of the case and see what are the surrounding things.
how can we go into the background of the case?
No, just
We can go into the facts what have been stated in the allegation. If you say that we can go to the background of the case, show us something.
no, little bit, Your Lordship. I'm not saying you have to go real deep into the case, Your Lordship, but that would not be the purpose.
No, we can give an interpretation also saying that since
Otherwise, we'll file an
since
objection,
the private
Your Lordship.
respondent,
We'll also
then-
file an objection on.
Is there any objection filed by the private respondent?
Private
Before the
respondent has filed.
mutating authority.
I filed an objection.
And what is the status of that? What is the status of that? What is the status of your objection before the mutating authority?
Mr. Paske.
Same says.
My objection, Your Lordship.
What happened? It seems that the sound is not going to him.
Am I audible, Your Lordship?
You are audible, whether this court is audible to you or not.
It's audible. Your Lordship, I have no instructions on whether
Yes.
what has been said.
Mr. Jindal,
Lordship.
show us something that we cannot go to the details of the investigation or the development which took place after the FIR is filed. Ganesh, can you give us something? But then make something direct, not this kind of things where you see. You give us something which this court finds is not at all relatable to the
previous
issue.
hearings. The question of mutation was more prominent, was looking more prominent.
See, where
For that reason, you know, to clear the doubts, these three judgments were looked into.
You give us something to show that whether the court can go into the details of investigation
That of course my friend has to what.
Or whether court cannot go into those things.
In fact, Your Lordship, the very documents they have annexed with the criminal petition also raise serious doubt about their.
We will not go into the documents. You
Because
see,
they have.
madam, the law says that the document which has been brought into record by the petitioner cannot be gone into to negate the allegation made in
the FIR. Maybe let's.
They may have, you see, this FIR may be entirely false. Okay, if we peruse that document, but then we cannot look into it and say that. Only you have to see, you have to take this allegation made in the FIR to be correct and see whether any case is made out. Now, so far as the bare reading is concerned, this court still feels that no cases.
No cases.
Now, you are trying to take this court to further things which
documents.
Now, for that, you have to show us law that we can go to. And that enclosure of the FIR, that should have been.
They are not given in the.
No, but then if it is, see, it should not be there that they should have been in their possession. Whether it is there in the record of the state or not, that is something.
It is.
It is not in the state record also.
So you should have pointed it out before, because this FIR, the entire FIR should be enclosed with the petition, not in part.
The annexure 4 right from beginning not there.
That is also an FIR, Your Lordship.
That is also previous FIR, and they are trying to hide
Anyway,
it.
it is when you made a part of this FIR.
Yes.
Okay, so we have to see what is there. We'll see.
And that FIR was lost by them only.
That is all right. That is all right. But then once it's a part.
And that was closed because investigating agency found that it is a case of civil nature. Similar type of FIR was given.
When shall we have it?
2 weeks, Your Lordship.
Otherwise, we will forget, Your Lordship also.
This I do not know, Mr. Jindal. There is division benches and all. Again, this court will have to rise for division bench. There will be 2 division bench.
The day Your Lordship is not having division bench, that day.
So that court cannot anticipate.
It is fixed.
After 2 weeks, Your Lordship may fix. We'll take a chance.
After 2 weeks, Your Lordship.
2 weeks will it not be too long?
Too long, Your Lordship.
Your Lordship actually have some family exigency, Your Lordship, for a week. So that's the only request, Your Lordship.
Okay. Hard learned counsel for the parties at some length. Can you give a stop at the request made by the parties? List this matter after 2 weeks for further hearing. Please enlighten the court about with regard to all those aspects.
Item number 14.
Deeply obliged, Your Lordship.
Yes.
Please move on. No, this is more or less of an application seeking for transfer from a village court to a subordinate district council court. The Lordships, here, I have instituted a suit in the year 2007 by my late mother. My lord, the respondents contested the suit, and in the year 2014, the evidence of my mother was recorded by the village court. And thereafter, the suit was last posted in the year 2021. The Lord agrees again the same. I filed an application seeking for transfer in the year 2022.
Because of the delay?
Because of the delay. Then by order dated 30/4/2024, my lord, my application for transfer was dismissed on the ground that the delay in disposal of a suit is not a ground to transfer the matter. Now, against the same, I prefer this revision petition on the order 6 and 7 of the Meghalaya High Court orders, jurisdiction over the council. Your Lordships kindly have orders 6 and 7.
That is all. This revision under Rule 6.
My lord, 6 and 7.
The Meghalaya High Court jurisdiction over
Yes.
the council court. Yes. Now, the grounds of rejection.
Yes.
Where the court said that the delay of disposal is not a ground for transfer.
My lord.
It is correct in law or not correct in law?
My lord, right, yes, it is correct.
It is correct in law. Then
No,
we
but-
cannot entertain revision.
But again, Your Lordships, the
Revision only when there is a jurisdictional error. Now, Rule 6 of the Meghalaya High Court jurisdiction over district council court and Rule 36A has been you see, like treated to be in perimeter with
Mal.
section 115. So you have to confine to the jurisdictional issues. Now, where is the error of jurisdiction in while court passed that order?
No, here I would say, rightly or wrongly, I think my colleague has not raised the issue before the learned trial court. You should have at least made some submission.
If he doesn't, let
My lord.
us say, if you say that the grounds on which your transfer application has been rejected,
Yes.
and ground is that the court below has said that
Delay in disposal.
delay is not a ground
My
for
lord.
transfer. Now, to dislodge it, you should show us some law that it is not correct in law. Then we interfere.
No.
Or otherwise, if you have conscience, then only we may. You have any objection to the transfer?
Lordship, we have objection to
You're
transfer,
happy with the
Lordship.
delay?
Lordship.
They're happy with the delay, my lord.
You're happy with the
No,
delay?
no, Lordship. Lordship, in fact, the impugn order which the judge of district council has been passed, Lordship, that order has also not been challenged under this revision. So this revision itself is not.
This is more or less a transfer, an application for transfer.
No, what do you have challenge? Where is it order? We are
The order is at page 25.
Impugn order is at page 25. They have not impugned this order, Lordship.
There's the impugn order.
This is the impugn order, whereby the judge said that there's no law that a case can be transferred on the ground of delay, Lordship. This is the order, Lordship.
So for saying that he has passed such a long order,
Lordships, can you have page 30?
where is the relevant part?
Page 30, my lord.
Yes.
If Lordships, can you have the second?
Yes.
The ground stated, yes, from the ground stated.
Yes.
The ground stated in the transfer petition is delay in disposal of the Diwani case number so-and-so and Miss case number so-and-so in the village court, Ilaka, Joy. The petition has been filed under Rule 39 of the Joint Autonomous District Council, Rule 2016, and in the said rule, no ground is provided for transfer of cases from village court to the subordinate district council court on delay in disposal.
What the Rule 39 to specify certain...
No, my lord. Lordships, can you come to page 29? Here, Rule 39 has been reproduced.
Provision of 39.
Yes.
The Rule 39, which you invoked.
Yes.
Does it lay down
page 29?
certain condition on which...
Lordship, that is reproduced in the order itself.
Yes.
Page 29.
Yes.
Second para.
Yes.
Seen the provision of Rule 39 of the Joint Autonomous District Council Rule 2016 regarding transfer and withdrawal of cases which empower the district council judge to transfer the same. No, my here. Can you have Rule 1?
Yes.
B, sub Rule 1. That any particular case or class of cases be transferred from a village court to a subordinate district court, from one subordinate district council to another subordinate district council court. Then Lordship, can you have Rule 3? Next page, ma'am. The district council court may act either on the report of the lower court or on the application of a party interested or on its own initiative. So
that is active.
Yes, on the basis of this, we have a.
It doesn't say how to. But then otherwise, the power is confined to the grounds which has been
under Rule 39.
Subclause 1, 39.1.
39.1 and 3.
2, yes.
1 and 3.
So it is correct. The lower court was correct in saying that the delay of pendency is not a ground.
My lord.
So you have no problem with that. So far as the law is concerned.
No, my lord, I am here before Lordships.
Now, if you want the order to be interfered with, on what ground? Because revision we also have limited.
True.
The principle of equity may not apply.
My lord.
And then Mr. Nangpi was saying that you did not challenge this order.
My lord, I'm not impeached. This is more or less, my lord, I filed an application seeking for transfer.
No, but then how can you seek transfer in a revision application? Then you have to wait to file proper application. Transfer petition may not be in the jurisdiction of this court. We may interfere in the revisional jurisdiction.
Yes.
But then so far as the original jurisdiction is concerned, we don't think.
Well, I also made a submission in the initial stage also, like if Lordships are not willing to transfer the matter, this direction may be given to the village court to expedite with the trial, my lord. Because I have made a prayer within a time frame.
We're okay with the expeditious disposal of the trial, but not for transfer.
Right now there will be no time to pass order, dictate order.
Lordship. You can come back
So,
next week. Lordship.
Let us have it next week, and then if we
You can
have
come back next week. Lordship.
My lord.
hard line consider the parties. Then you say at the joint request made by the parties, this is matter after a week. This say these are small matters, we can dispose it.
True.
But then yes, how many more matters are there?
Obliged.